9:03, and I call to order this August 26, 2025 session of the Special Magistrate proceeding pertaining to the City of Daytona Beach rental program. My name is Robert Riggio. I am the Special Master who will be presiding over this proceeding. And I welcome you here. You will all be given as much opportunity to speak as is necessary and you feel you need. So sit back, and it should be a fairly quick session. We only have about 6 matters, I believe, that we're hearing today. And so hopefully we'll be able to get you out of here fairly quickly and make a determination as to how to proceed with each of these matters. A simple thing about our process, there is you probably all saw the agenda for this meeting, or if you haven't, there's one outside, and I will be calling the matters in the order in which they appear on this agenda. And at that time, you need to come up to the microphone, which would be on your right on this far side. And at that point, state your name and address and be sworn in. If you are not the respondent in a matter but are speaking for the respondent, then you will need to, at that time, also state how it is that you happen to be here on behalf of this person. Once you are sworn in, the city inspector will come forward over to this microphone and proceed to list the city's position regarding the matter and provide the various facts and arguments that I will be making my decision based on. There is an attorney here for the city who will also be probably providing some input into these proceedings, and she will come forward as is appropriate to make her presentations. Okay, let's go to the next item on the agenda. Are there any announcements?
The city is going to be withdrawing lien review number 3.
Okay. All right, anything further?
That's all.
Okay. The next item on the agenda is the approval of the July 22, 2025 meeting minutes. I have approved them and I have provided them to the board clerk. And at this point, we move on to the hearing of cases. Okay, the first case is going to be RTL 08-2542, 5 Family Houses, LLC. Cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 815 Vernon Street. Oh, before we get to the case, Madam Secretary, can you swear in the inspectors?
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Okay. All city staff who will be giving testimony have been sworn in. Is there anyone here on behalf of 5 Family Houses, LLC? No? Okay, we do not have a respondent present, but has this entity been properly notified of today's hearing?
Yes, Your Honor.
Okay. Mr. Yates.
It was a zoning violation. This case was field generated. The property is zoned SFR5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed July 10th, 2025, and they were notified the same day. The property stopped actively advertising as of July 18th, 2025. The daily posted rate was $212. The check-in, check-out time shows 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. I would point out that the city can request a fine of up to $15,000 for these irreparable and irreversible matters. Does the city's attorney have anything she wishes to put in the record?
Yes, I do. So the city's position is that the beneficial gain to the property owner whose advertising conduct that is prohibited by city's code is unlawful and pursuant to Florida statute 162.06 subsection 4 is irreparable and irreversible. The effects of renting property or holding out property as a vacation rental cannot be reversed or repaired. The information has long-ranging effects in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertisement can potentially book a property for the whole year. These promised days are potentially to the detriment of the patrons and definitely to the detriment of the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspections, proper licensing, proper insurance, and proper taxation required by law. And I want to emphasize that these properties have staff on site 24/7 to address any emergency concern that patrons or the community may have. We are here today because there was a big push from the community that I believe it was an event, a truck event, where residential neighborhoods were getting flooded with people who had no regard for the people living there, blasting music at all hours of the night, causing fights, crime, and the residents had no recourse, right? Those vacation rental property owners weren't available at 2 a.m. to take those guests out. They didn't have the proper staff or security concerns, and for those reasons, we are here today to enforce the prohibition against short-term vacation rentals. The weighing unlicensed, uninspected, not insured, and just improperly staffed short-term rentals against the regulated businesses who underwent the proper safeguards is unfair and harmful to the regulated business community, the patrons, and the residential community. The monetary effects of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against lawful accommodations, businesses, and lawful vacation rentals. The transient nature of the rentals limits the means of enforcement, typically to identifying the advertisement, because by the time code enforcement arrives to the property, the transient patrons are either typically gone or claiming a misleading relationship that are often contradicted by advertised visitor comments. The community effect is that the transient business used within unauthorized residential neighborhoods affects the density, parking, noise, and overall safety of the community. They affect the peaceful enjoyment expected in residential neighborhoods. It diverts from traditional and reliable residential norms. Thus, we have seen vacation rentals go for amounts of several $1,000s a week, and realize substantial fines is the only detrimental tool. Because by the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable and irreversible in nature. Also, given the gravity of the violation, a fine of up to $15,000 is warranted pursuant to Florida statute 162.09 subsection 2D. Thank you.
Thank you. Mr. Yates, anything further?
No, Your Honor.
Okay. Well, based upon the quick actions of the property owner, I would agree that a lesser fine is warranted, and I am in agreement with the $1,000 fine. It's commensurate with other proceedings that have come before me. So therefore, in case number 1, I hereby find the respondent, 5 Family Houses LLC, in case number, or in RTL 08-2542, as the owner of the property at, let's see, 815 Vernon Street to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes. The property has subsequently been brought into compliance on July 18th, 2025, and hereby order that the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Okay. Case number 2, RTL 082543, Spencer Perry Jr., Jennifer Perry, and Isaac C. Perry, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 1216 Sunland Road. Sir, if you could state your name and be sworn in by the clerk.
Yes, Your Honor. Spencer Perry.
All right, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Mr. Gates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed August 6, 2025, and they were notified the same day. The property stopped actively advertising as of August 7, 2025, and the daily posted rate was $211. The check-in, check-out time were shown as 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz, do you have anything to
Were you present when I read my speech?
I was, yes. ma'am.
Would you like me to repeat it, or do you mind if we just read it into the record?
No need to repeat it.
Thank you.
Okay.
We just asked that it be read into the record.
Okay. Then the presentation provided by Ms. Diaz in case number 1, RTL 082542, is hereby incorporated into this particular proceeding. And now, Mr. Perry, please understand, Ms. Diaz has simply raised an argument, and that's placed into the record. You are free, if you have any objections to anything she said, to state to the contrary or whatever you wish.
I'd just like to make a statement.
Sure.
So the other two owners aren't here, my wife and my son. We purchased the property at 1216 Sunland for my son to live in. We never intended it to be a vacation rental property. He attends and goes to school, and he works at Embry-Riddle, and he's going to be here for the next 4 to 5 years. So the house was his. There's a few months where he is going to have to live on campus, and it was for that reason that he listed it on the site. It was a mistake, but it was out of ignorance. We didn't know the rules, which is not an excuse. As soon as we found out about it, we contacted Mr. Yates. That same day, we took it down and called him again and had him confirm that it was down. So that's what I just wanted to say. We like the house. We like the neighbors. We hope that we did not do any damage, irreparable damage, and we plan to be in the neighborhood for a while. And so we made a mistake. The mistake was out of ignorance, and we ask for leniency and mercy. That's all.
Okay. And what is the city's response?
I mean, the recommendation remains the same, but we take no issue if for some reason you feel it should be lower.
Okay. Ms. Diaz, do you have anything to add?
we're always sympathetic, especially when someone comes before us and explains what happened. However, we have to have consistency. For example, we recommend $1,000 across the board. It used to be a standard fine of $15,000, he can tell you. So we feel that given the previous history of the maximum fine, lowering it to $1,000 was fair. But we appreciate you coming. And you mentioned he needed it to rent for a couple months. If you get with Mr. Yates, I'm not sure if you're qualified for the long-term rentals, but he can tell you about that. We just don't allow short-term rentals, which are less than 30 days.
Understand.
I believe long-term rentals are 6 months and a day, and that would probably be longer than the several months that you say.
Yeah.
Okay. Okay, under the circumstances, I'm willing to reduce this, but try to maintain the consistency to $750. And that's because your son is a student at Embry-Riddle, and what you have said makes sense. And so that's the best I can do, but I can't vary much further from that.
Understand. Thank you, Your Honor.
Okay. So therefore, in case number 2, I hereby find the respondents Spencer Perry Jr., Jennifer Perry, and Isaac C. Perry in case number RTL 082543 as the owners of the property at 1216 Sunland Road to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner in a damaged surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes, and the property has subsequently been brought into compliance on August 7, 2025, and hereby order the respondent shall pay a fine in the amount of $750 and not violate that section of the Land Development Code again. And for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you, Your Honor.
Case number 3, RTL 082544, Georgia R. Hines, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 109 Briar Creek Circle. Ms. Hines, if you could be sworn in by the clerk.
Please state your name.
It's Georgia Hines Loban.
Okay, can you speak a little louder?
Georgia Hines Loban.
Okay. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed August 7, 2025, and they were notified the same day. The property stopped actively advertising August 7, 2025. The daily posted rate was $93. The check-in, check-out time were shown as 12 p.m. and 12 p.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz?
Good morning, ma'am. Were you present previously when I read my speech about this
Yes, I
position?
was.
Would you like me to repeat it, or do you want me to read
No,
it?
you're fine.
The city requests for it to be read into the record.
Okay, well then, Ms. Diaz's presentation regarding the city's arguments that these matters are irreparable and irreversible, as stated in case number 1, RTL 082542, is hereby incorporated into this proceeding. But Ms. Hines, please understand, as I said before, it's simply an argument, and if you object to any of that, you certainly can present any arguments you wish in opposition. Okay, Miss, does the city have anything further?
No.
I just want to say something.
Excuse me?
I just want to say something.
Yes, please. It's your turn now.
Oh, okay. Yeah, like, case number 2, I had no idea this was, like, you can't just list, your... So I listed my guest room because I had just recently lost my job. My husband is deployed. Like I told the inspector, like, I had no idea. As soon as he came and told me, I took it down. I didn't know any of this. That's it.
And I will note that it was down within an hour of posting.
Okay.
Yeah, and I never got any monetary gain. It was never rented.
And I never saw any evidence that it was rented.
Okay. Ms. Diaz, does the city have anything it wishes to?
We defer to your ruling.
Okay. I've had people in front of me who have grossly violated this ordinance, and in people who have, according to Mr. Yates, you said the very day that she was notified, it was taken down.
Within an hour, actually.
Within an hour, okay. I wish the word was getting out more so that people would know that. I know I've been hearing these now for, it seems like 5-6 years. And it's still not getting out somehow into the community. And I understand the situation. Mr. Yates, is there any, did you find any evidence that this property had been rented or?
No, sir.
Okay, and the posting, I know sometimes there's reviews and things like that, was that?
There were no reviews, and it was listed as new on the site, which generally means that it's been up less than a month.
Okay.
Now, it can be up much shorter than that, but that's usually a cutoff, my understanding, to be listed as new.
Okay. I still have to render a fine in accordance with what I've done in the past, and I know this lady moved very quickly to get this resolved. And I'm considering $500. There still has to be some fine for this because it still constitutes a violation of the code. And it took up your time. It's taken up other staff time to resolve it. And so therefore, although I typically, in these matters where someone is brought before me on the very first time without any past record assess a fine of $1,000, but I will reduce it to $500 this time. But I'm sorry, I do have to assess a fine. So therefore, in case number 3, I hereby find the respondent, Georgia R. Hines, in case number RTL 082544, as the owner of the property at 109 Briar Creek Circle, to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and as such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.009 1D Florida statutes, and the property has subsequently been brought into compliance on August 7th, 2025, and hereby order the respondent shall pay a fine in the amount of $500 and not violate that section of the Land Development Code again. And for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Sorry, I want to say something.
Please do.
Like you mentioned that this information is not getting out there. I just wish, there is something that can be done to prevent this from happening to other, citizens in our community, because I understand that I guess it's our responsibility to know the laws and, the rules and whatever, but even to have Airbnb prevent you from posting, if that's the case where you're not in an area where it allows.
One thing I will say, and I understand exactly, I had kind of hoped that when I started doing these that Airbnb would somehow get involved, but they will put, so far as I can tell, any address up on their website, regardless of whether it's allowed or not allowed.
Right.
I believe.
Go ahead, please.
No, I got you.
And this is in a way a business, and I know the city, if I'm correct in this, if someone contacted them and said, I would like to rent out a room, there is a business tax license for long-term rentals, and they would also probably say if you're saying short-term rentals, you can't do it. So the city does have, there is the ability to find out that you can't do it. It's just that most people don't take that next step, which is just call up the city and say, can I do this? I mean, it's something out of the ordinary. I mean, I would expect it if you were going to, I know even to, in some places, and that may be in Daytona as well, if you're going to have a yard sale, you have to get a license for it, and that's something that people think, well, I can just do this in my yard or what have you, and that if you do it without getting the license, you're technically in violation of the code. So unfortunately, and maybe the Florida Supreme Court had weighed in on this a long time ago and said that you are on notice of all of the ordinances, whether you have a book of ordinances in your house or you come down to City Hall and read through them, or whether you just take it on your own and choose to do something without trying first to find out if it's a violation or not. And so, that's not, and as far in the Florida court system, that ignorance of the law is not an excuse. And that's basically what this comes down to. I'm trying to be as helpful as I can within what I consider the constraints.
All right, thank you.
Mm-hmm. We now move to continued cases. This one is irreparable and irreversible. Case number 5, RTL 05-2530, Joanne DeBaron King, cite for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 507-509 Jessamine Boulevard. This is a continued matter. I'll read continued from the August meeting for consideration of the imposition of a fine for irreparable and irreversible violations. Now, my recollection of this, when this occurred at the previous time, was that Mr. Yates, you had stated that you had discovered this property listing as a rental on which website was it?
Airbnb.
Airbnb. Okay. And
I'm sorry. VRBO. Yeah.
VRBO. Okay. And that Ms. King, you had been cited previously in the past.
I need,
Uh,
Mr. Reggio.
Yes.
I need to swear her in still.
oh, okay.
Ms. King, can you state your name for me?
Julia DeBaron King.
All right. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay, I'll carry on where I left off. Was that this property had been cited and a fine of $15,000 had been imposed. This was some years ago. So Ms. King was certainly aware and on notice of the city's ordinance and this particular provision. I was presented with the evidence, which I am usually provided with, of a posting. And Ms. King, at that time, stated that no, that posting, that materials which were now on the internet were somehow in error, but could not elaborate as to any reason for that. And so this matter was continued because the fine that could be imposed in this matter, should there be a violation, could be up to $15,000. And I wanted to give Ms. King as enough time as she could possibly do, see if she could dig up something to support her contention that that was not her advertisement, that somehow it was posted without her knowledge or however. And so, does that, Ms. Diaz, does that fairly wrap up what transpired?
I have a speech before we prepare, and I wanted to give Mr. Yates a second to present his case first, and then I was going to read mine, and then we'll get
Okay,
there.
well, we can go through that just so it's in the record. Mr. Yates, if you could just go through this quickly.
Yeah, absolutely. I'll go through it quickly, sir. The case before you was a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed May 1st, 2025. They were notified the same day. The property stopped actively advertising as of May 6, 2025. The daily posted rate was $120. The rules showed no smoking and no pets. This property has generated multiple citizens' complaints for short-term rental. This is the second violation by this owner at this address, the first being CEB 02-1612 on April 14th, 2016, and the citizens' complaints generated were ISU 2005-0153, simply for short-term rental. That does not have a contact because it's older than the reporting requirements. And the second is ISU 2104-006 from Lisa Starr, saying that it was a short-term rental. Due to these actions and the nature of them being irreparable and irreversible, the city is requesting a one-time fine of $15,000.
Okay. Mr. Yates, you said that there had been 2 violations?
This is the second violation.
This is second, okay. And so the first one was back in April of 2016,
Yes, sir.
okay? And was that ultimately corrected?
Yes.
Okay. Ms. Diaz, do you have anything that you wish to?
I do, Your Honor. So the city would like to emphasize that the city is not required to prove this case beyond a reasonable doubt, as it is in a criminal case. Instead, the standard of proof is preponderance of the evidence, which means the city must show that it is more likely than not that the violation of the city's code has occurred. In other words, we only need to prove the violation occurred by 51% certainty. If the evidence tips even slightly in the city's favor, case law dictates that the standard has been met. Here, the evidence does far more than tip the scales. The city's land development code prohibits this type of short-term rental under section 5.2.A.2, note 1. Other accommodations to include vacation rentals and transient lodging, which is not permitted in this zoning district. And Section 11.5 defines other accommodations as a dwelling unit that is rented or leased to transient persons or tourists for less than 6 months. In this case, the respondent advertised the property on Verbo, and under City Code Section 90-298, that advertisement by itself creates a presumption of liability. Further, Florida statute Section 509.013, subsection 4A1 provides that transient public lodging establishments include any dwelling advertised or held out to the public as a place regularly rented to guests for less than 30 days or 1 month. By advertising in this way, the respondent violated the city's prohibition on short-term rentals. In addition to the unlawful advertisement, the evidence also shows, first, the respondent argues that she did not post this listing. And to counter that, the city points to historical precedent where providing the property's advertisement is geotagged to the respondent's address with the name of the respondent as the listed Verbo host, and pictures of the property has been sufficient historically in the past to prove by 51%. The city isn't required to present more information. We discussed a subpoena previously, but we don't have the resources to get binders and papers, let alone pay for the hundreds of dollars that it would require to get a subpoena.
Ms. Diaz, if I can interrupt?
Yeah.
I don't recall any testimony at the last hearing regarding geotagging.
Oh, I just meant not the last hearing. I'm talking about historical precedent. He puts up the advertisement, which has a map and
Okay.
a little tag of the property. So that has in the past provided, in addition to the listing itself, enough
Okay.
evidence to prove.
I don't think that there was, if my recollection is correct, that there was any disagreement that the posting was the property that had been previously posted back in 2016.
There was. She alleged that the listed property on the advertisement was a different property in the city that was designed exactly the same, but she did not provide an address or any proof of that property,
Okay.
nor a long-term business, a long-term rental license for that property. So it was just a vague claim that it was some other place. In addition, as he said, there's been a previous violation. And lastly, the respondent also argued that she did not post this listing because her identity was stolen. The letters that she proffered as evidence that her identity were stolen were generic letters from banks that we all received saying there was a data breach and your information might have been compromised. Even so, that letter was received far sooner than the violation. She had plenty of time to investigate, do a police report, freeze her credit account, which she didn't, which shows that she really didn't believe that her credit was stolen. So therefore, under the governing standard of preponderance of the evidence, the city has more than met its burden. The facts show more likely than not that the respondent engaged in the prohibited short-term rental activity. Accordingly, we request that you grant our request for fine.
Okay. And Ms. Diaz, did you include, was your statements that you have read stated earlier regarding to irreparable and irreversible made a part of the record?
No, it
in the
wasn't.
previous
I apologize.
proceeding?
Were you present when I read my speech earlier?
Sorry?
Were you present when I read my speech, the same one? Would you like me to read it again, or is it okay if it's read into the record?
repeat it.
Okay.
Into the record?
Then I will incorporate Ms. Diaz's arguments regarding this matter being irreparable and irreversible into the record. That's just an argument. Ms. King, you're free to, argue against it or
you
make
ready
your
for me?
arguments. Well, I just want to make sure we clear up everything, because I would like to hear something, because at this point, I have to agree with Ms. Diaz simply saying that that there was some data breach or something of that nature is sort of like the dog ate my homework. I put it on par with that. I need something solid that I can make a decision on. If that's, your contention that somebody maliciously or whatever, for whatever reason did this, I wanted to give you ample time to try to find some kind of proof other than speculate. because speculation doesn't get anywhere with me. So, Ms. King, please proceed.
Okay, as far as the identity goes, my VA card, my license, and my social security has been compromised. $8,000 was tried to be removed from Wachovia, and all accounts were shut down. And the manager of Wachovia took care of that. Now, as far as the...
Are those were your accounts?
My accounts were, yeah, somebody tried taking $8,000 out of a savings account using the IDs that were missing from me.
I just want to
haven't
be
gotten-
clear on this because everybody now seems to get these letters these days that your data
God I
has
did.
been breached, but you're saying that in particular, your particular accounts were breached at Wachovia.
Yeah.
Did they take anything?
$8,000 was something that they were trying to pull out of my account, and thank God I know they, Wachovia manager and Carlos, called me and
Okay.
made me aware. And actually, this made me look more into, and I locked down most of my things. I still haven't got my VA card, but that's all been down.
We object to relevance because even if this is true, it's not relevant to the case. No one can make money off a listing if they don't rent it to the guest.
Well, I understand that, but it's giving, it's...
Well, you're calling me a liar that my ID
Ms.
wasn't
Diaz,
stolen. I mean,
you said that she had no evidence to support that her data had been breached. And she is, if I understand, presenting evidence that in fact, unlike in other situations where someone gets this amorphous letter in the mail that says you may have a problem, she has actually had a problem. That's what she's testifying to.
So we
You
just
actually
argue. We
brought
just
it to my
argue.
attention.
We
But
argue.
it sets a groundwork, but it has to go further.
Okay, I just want my objection on the
Yes.
record that it's not
Okay.
relevant.
Now,
That's fine.
when I was notified, I had asked Kevin for the, he said there was complaints on my property, and I asked him for the website and showed me the complaints, and he did. And this is the complaints that you gave me, right? All of these?
No, ma'am,
This came from your...
No. Ma'am, that is a list of photos from your property. That is a list of uploaded documents. That's not a list of complaints. I listed the complaints earlier. It's IS.
Those also.
Those are the complaints.
Okay.
Yeah.
Those
wait,
complaints go
Did we move
back.
on? Sorry, did we move on from the identity theft? Because nothing was actually proffered into evidence.
And now the second part is we do request the evidence that what you just said happened. So something do you have anything from the bank saying the money was attempted to be stolen or something like that?
That's not even, you did me a favor by giving
Well,
me a
wait,
heads up
ma'am,
on
before,
that.
no. Before we move forward, do you have any sort of
I just
thing to
have-
submit from the
I just
bank,
have
a letter?
No, I didn't get
So,
it.
so
from-
no, you have no evidence.
She has her testimony.
Okay, I just-
It's sworn testimony.
Okay, so these are the things that I pulled up with the complaints, okay? And they date back into the 16th to 20. Now, when I bought my house, I bought it from a realtor, and I had a state license for a vacation rental. I had no idea it was against the law in Daytona, but the state issued me a license 2 years in a row. Okay? And those complaints, the first complaints, led into me filing to be a bed and breakfast. Okay, so we have heard those complaints and all of that was in there. That would cause this case to become, that would cause this case to become double jeopardy. I've already been in front of the courts with those complaints and went through thousands of dollars to become a bed and breakfast because I was historically significant. Tom Klee, who happened to be the code enforcement, encouraged that. Okay, so all of those complaints that were shown to me were back and they were all closed if you open it up. And it wasn't even a picture of the room that he's saying that was there. Let's see.
Excuse me a minute. I'm confused. Is this property a residential property or is it a bed and breakfast?
It didn't get to be a bed and breakfast because after I went through all the process, they denied me the bed and breakfast. I saw, got approvals from most of the stuff, and then they changed the square footage to be a bed and breakfast.
So can I respond to a couple of those points, Your Honor? To the point of double jeopardy, res judicata wouldn't apply in this case because this is a new violation. what the suit was in 2016 was for the violation that occurred then. This is a new listing, so res judicata would not apply. Second, regarding the license, I'll let Kevin.
I'm trying to get what I consider the basic facts, okay? Some years ago, we had a gentleman, I think it was before Mr. Yates was involved in this, who had been fined for having a short-term rental. And then he got a bed and breakfast license, and then he was okay.
I believe the gentleman might have been rezoned. I think it was the
Yeah,
gentleman right off Main Street. And,
Yeah.
But what the
And
city...
I'm saying that and I saw references to bed and breakfast and stuff.
Yeah.
But bed and breakfast seems to me to be totally irrelevant. It's
can-
not a bed and breakfast.
Can you pull up my zoning table, please, guys, from the...
Well, I think...
Well, off the top of my head, I'm not sure that area would... Either way, the point is that currently, this property is not a bed and breakfast.
That's correct. That's my
And so,
understanding.
regardless of its ability to become one or not, simple fact that all this advertisement happened before that would mean that it is in violation. It is a zoning violation, and more specifically, it is a short-term rental violation. The next point, just to the closed status of complaints, to be clear that while a complaint is closed, it is not sealed. So we will continue to use the facts of the complaints in the case, even after they're closed, to demonstrate a pattern.
Okay. Mr. Yates, this property is not a bed and breakfast.
Correct.
Okay. It may have applied for this years ago, but the facts we're looking at right now are May 1st of 2025. And it couldn't be a bed and breakfast, or it isn't a bed and breakfast on that date.
Correct.
So that's irrelevant.
Yes, sir.
Okay. So, all right.
only
The
brought
city would
that
like to
up.
highlight that the respondent is versed in the law. She has prior knowledge of this violation, that she can't do this. She knows, and we argue that she advertised anyway. The careless nature of it is why we're taking such a hard stance on it. The conscious disregard for the rules.
Okay. I'm hearing you. I'm hearing arguments that I feel right now have no bearing. There's no bed and breakfast there. So
there's a
then
lot
it
of
can't be it can't be short-term. It can't be a mistake. And the bed and breakfast was turned down a long time ago.
And I also want to add, in addition to arguments that have no bearing, even if her identity was stolen, which we contested wasn't.
Well,
because
let's hear her arguments as
finish?
to how the identity theft, and maybe I need to be clear on this. There's a posting on, was it
VRBO.
VRBO, and there is a contact person, is my understanding usually.
Yes.
Who was the contact person?
The defendant.
respondent.
Respondent, sorry.
The respondent.
So I just want to get this on the record, if you may, please, Your Honor. Even if it was true, I contacted VRBO. They said they pay out once the guest leaves, meaning that the guest would have had to have access to the building. Someone who stole her identity would have wasted their time and not been able to make a profit. Who would waste time and make a listing if they can't make a process because they don't have access? The only person who would benefit from this listing is the person who owns and has access to the property, which is the respondent.
And just to answer your question, as you see, the property manager listed there does match the respondent.
Okay.
It listed to a Joe Tamim.
It's
That's who it was listed
it's right there, ma'am. I have the copy. Would you like to read it?
And this is all new to me. You're the one that brought that up to me as far as that goes. And the picture is from, you came to my house. This is the other thing. He came to my house. Once I found out that this was going on, came to my house and the room was not the same room. And he admitted to the fact that the room was not the same room.
Objection,
And-
counsel.
Objection, yeah.
Well, look at the pictures.
You're misstating what he says, which goes to your credibility. He did not make that
Yeah,
statement.
to be very clear, sir, I wouldn't make a statement that
you
was a
can
different
object, but the
room.
rules of evidence are loose in these proceedings, and
sorry.
I'm trying to figure out. The city has presented, Ms. King. evidence that is, for me, sufficient for a finding of a violation. And your argument has been that no, it appeared somehow mysteriously, and you have no idea why. And that's speculation. I'm balancing what I see versus what you conjecture. That's not evidence. I'm trying to figure out how that appeared, who would, and if it did appear and somebody was doing this, why they were doing it. I have no idea. I'm having a very big problem, and that's why I gave you time, because this is really between you now and VRBO. The city doesn't have access to VRBO. You do. Somebody put this up there. And somehow VRBO probably has a record that probably only you can obtain.
Oh, I've done that.
You have, okay.
It says that invalid ID, okay, no money has been made on, says I'm a property manager, wouldn't say that at all.
Okay, so it does say you're a property manager in there?
It says that, the property manager, and it's a Joe Tamim, okay? It says no monies have been made, no bookings or no monies have been made for all of that time.
Well, that's not relevant either.
Of course not.
Whether there's booking
And
or
on
not.
top of that, even though Kevin came to my house, inspected my house.
And here's one from
Miss-
VRBO. Somehow they have her
Miss
tax
King.
ID and all her contact information. So it'd be
Do you have any
not
objection with my seeing this information?
I'm sorry?
Do you have any objection, Mr. Yates just handed?
Okay.
I'm not, these are your documents. If you wish me to see them, you need to authorize me. Okay, then you're fine that I see.
Fine.
Okay. Okay. I don't disagree that your name is the only one that shows up here. And there are statements that there are no bookings. Okay. I've heard these matters before. You don't have to have a booking to be in violation. And let's have that entered as Exhibit A, or Respondent's Exhibit A. We're going to, Ms.
Well, this
King,
is after I started questioning them. They said no money has been forwarded my way. And on top of that, after Kevin visited my house, he tried booking my house. So, I mean, that I consider to be an entrapment, even though,
Ms. King, let me point out, somebody posted that advertisement. And VRBO, the city has no idea. All that advertisement goes to your property. You have stated that you believe that somebody other than you posted that.
these pictures are from Zillow. This is from Zillow. When my house was listed, these pictures are from Zillow,
Okay.
that room. And when Kevin came into my house, he knew exactly where it was. So perhaps it was that Kevin's been trying to bust me for the last 10 years, and I'm saying that he made up this case just to, finish it off because he's got everybody else in town and I'm the last whale.
The city feels that it's presented sufficient evidence to prove the violation, so we would ask for a determination.
Okay.
And you
Ms.
asked
King.
for, you tried to subpoena VRBO and got nothing.
No,
No,
objection.
that was withdrawn, and the reason it, well, I don't know why it was withdrawn. I received that subpoena. Your name wasn't attached to it. I feel that you should be notified if the city is sending out a subpoena that what they're doing, and if you've got an objection, you have an opportunity to do so.
Just-
And then the next day, I believe I received that
Yeah.
it was withdrawn, so it never was sent out.
Yeah, to add to that, we didn't want to set a precedent of having to, because it would have been hundreds of dollars to get a process server, pay for the information. We didn't want to set a precedent of having to do that for every case, because again, we met the 51%, so that's why we withdrew it. We didn't have the funds to get the subpoena.
Can I ask where the current complaints are in the house? Is there any current complaints?
No new complaints have been generated since the website has been taken down.
How about before that website was taken down?
Objection relevance.
I've submitted the complaints and listed them to you earlier.
And that's the complaints that you had, and they were all closed complaints because they came when like I said, I had a state license, didn't know Daytona City ruled that. All those complaints have been closed, and that would be a double jeopardy.
Objection, Your Honor. The city has prevented its case. We don't believe that she has provided anything to counter any of our arguments that the listing was advertised at her property in violation of city code. We've already addressed all of these claims. It's not res judicata. This is a new violation. This is the first time that this violation is before you. I could go through the speech
Okay.
again if you want.
And the other thing I might mention is, everybody here is complaining about the fact that they didn't know. If realtors were,
Ma'am, you knew. You've been before this before, so you knew
I
that this
just
was
have an
unlawful.
opinion.
Let her speak,
I have an
please.
opinion. Okay, my house was sold to me by a realtor that set me up with an Airbnb. And they collected a commission and I collected a bunch of BS afterwards. If the realtors are fined for selling houses and telling people they can be a vacation rental, you probably wouldn't see a whole lot of people
If
here.
you tell me who the realtor was, I can reach out to them and inform them that they can't be.
I've already called and we have somebody on it in our neighborhood
Have
that
you
is
given
working
us
on
the-
it. I'll send it to you. I'll send you the closing papers, yes. Yes.
Okay.
I don't want the papers. I just want the name of the realtor
Okay, that's not a problem.
to help spread the word.
Okay.
So, I mean, this has been going on for years and years, and I do hold a rental license for both my front house and my back house. Even if I don't rent it, because I was told that if you don't have a rental license, you can't get one if it goes by a year or something or other, so.
Okay.
The city contends this was a conscious disregard of our rules, and we stand by our recommendation and ask for a determination.
Okay. My problem is that there is an ad for your property, and your claim is that you didn't post it.
I've never used Airbnb. Even in the beginning, it was Airbnb, my first experience with all of this.
I'm sure that VRBO has some information somewhere as to how that advertisement came to be. That is critical because the city has proven its end of the case. There is a property, which is yours. There is a posting, and that is sufficient to constitute a violation of this ordinance.
Other
And-
names, I want to know who Joe
The city is.
G-R-E-G-O is, and Sabine, and
Who are these people?
don't
Are they
know.
listed somewhere?
it's listed right there as the contact person is a,
Can I see that?
and they don't have information.
What I'd like to point out here is see how this.
Mr. Yates, it'd probably be good for you to speak into the microphone.
We'll need to submit that, but the only thing I would point out to you is that you see that how that says contact selector at the
Yeah.
bottom there? That means there's more than one contact and you can select which one you show. So most likely the property has two contacts, and as I showed you from the actual ad that we screenshotted that day when it was live, we don't know where that's from exactly, but from the ad, her name's on it. We can show that.
Okay.
So he may be a property manager, but what we know for 100% fact is she is.
Well, on the day that you saw it, whose name would have been there as the
That's an
contact?
exact screenshot right there, her name, and it's time and date stamped if necessary to prove the time that it was taken.
Okay. Well,
And here again, it says that the identity was not verified. And if you'd like to see if there is a license from the state,
Objection
they
relevant.
obviously didn't know Daytona wasn't, you know,
A license for what?
for a vacation rental in that property.
And when was that issued?
That was issued when I bought the house.
Oh, okay.
In 2017, that's when all these violations started. That's when I got busted for a short-term rental.
The state
And-
issue you're not the first one to have one of those licenses. The state doesn't seem to care whether or not it's legal in the community.
So I found out. But that's what brings us here.
Well, ultimately, the burden falls upon the property owner to do the investigation to determine all of these bits and pieces of the whether or not what their intended use can be made happen on that property.
Let me ask you this. It's on the internet, so it must be true, right? So when you pull up Daytona Beach, where's the Ferris wheel?
Objection relevant.
I'm just questioning, like you're saying you see something on the internet, you believe it, and when people look up on the internet to see Daytona Beach, they see a boardwalk. People come to see a
For the
boardwalk.
sake of time, we do have other hearings this
Okay.
afternoon.
Well,
I'm saying I didn't put that ad up. It says that I didn't make any money on it. There are other names. Like I said, it's, you can call Carlos over at Wells Fargo. I can get a statement from him. I didn't think that I needed, since I was under oath, that I would be called a liar.
Mr. Barron, Ms. King, this really comes down to not all these side issues. It comes down to that posting that was on posting that property being available for short-term rental with your name listed as a property manager.
And I did not even
And-
know about it until he told me about it.
Ultimately, that comes down to between you and VRBO. If they did something and they allowed somebody to access their website without their permission or without your permission and all of that, that is something that you need to work out with them, okay?
And I have been doing that.
Should you be successful in doing so, then right now I'm telling you there's going to be a fine, okay? And you might be able to come forward with a lien review and say, look, I was able to prove beyond a reasonable doubt that in fact somebody else basically sabotaged my file, okay?
You
Or
want that from
placed this.
You want it from VRBO or whatever that is? I'll contact
Well,
them.
they're the ones, that's their listing. They are the ones who put that up there. And what is up there says that you are a manager of a property holding it out for rent. And that satisfies what the city needs to demonstrate.
That's
You
kinda
now
what
have
it
to,
is.
what I had hoped to hear was that you had been able to find that somebody else posted it on such and such date and whatever, and that wasn't you, and it was somebody from Alaska or whatever, or something. But all I have right now is speculation, and city has presented me with facts. So,
I
I think-
did contact them, and then they said there was no tax information, there was no bookings. I mean, this is what they gave me. I don't know what else you want. as
Somebody
far as that
placed-
goes. They can't tell me who, Joe Gregorio or Joe Oreo, whatever. And Joe, to me, I don't know who that person is.
ma'am, the ad was there back in 2016, and then it went down. It's gone.
2016?
Or wasn't that where?
2016, it was tried, and that was already
The city
gone
prevailed in that
into-
case.
But it was taken down. It has
Yes,
been
it came into
off-
compliance,
It
yes.
was in compliance for a number of years,
Yeah,
and then suddenly it reappears.
yeah.
Somehow, somebody has to explain to me how it is that it reappeared.
I'd like that explained too.
Well, I can't, I'm looking to you to provide that information
I
because
thought I
it
did.
benefits you. The city has cited you for a violation, and they have provided the proof necessary for that violation.
And I thought I did by showing you there was no monies, there was no tax ID, nothing has been confirmed that it was me that put that up there. I don't know what else. I could
Someone put it up
possibly do.
there. That is, the city does not have responsibility, as far as I see it, to go and try and contact. And anyway, I think all that would be confidential anyway. Only you are the one who can contact these people and solve this mystery.
Sir, I
But
did
the
that.
mystery remains unsolved, and as far as I'm seeing right now, there's a violation. So, and I'm going to levy the $15,000 fine as requested by the city.
Well,
And
why
that should
would
give
do
you an incentive.
$15,000 fine when I've already been, like, the first violation was already tried.
you are not the
That cost me $20,000 to go for a bed and breakfast, and all that was dismissed.
Ma'am, you are not the first person who has been levied a fine like that and then chose to
that's very
violate
fair.
again. I have one or two, I think, that have now up to 3 or 4 times. And so that it does happen.
But I think
And so
that's
you
very
would
unfair.
have now 15,000 reasons to try and find out how that advertisement came to be on the internet.
What exactly would you like me to do when I go to them and they sent me this, all this stuff telling me that, how would I go when they have no ID?
Your Honor,
You
she can hire an
probably need to contact somebody who is familiar with items like this, who's maybe schooled in electronics, or a lawyer who handles this
Yeah.
type of thing.
Your Honor.
It's not up to me to tell you how to do it, because this is your problem. And you need to find a solution to it.
I thought I did by showing that, nothing was coming out of it, and
No.
so I don't know what else what is it that you want, and as far as
It's the
$15,000,
city's
like I
contention
said, you're
that we are
trying me for a
not
second
able
time
to
around.
give her legal advice. If she wants to contest this, she can hire an attorney.
I think it's pretty clear. I want to know if you're alleging that somebody other than you placed that ad, who that person is, and be able to demonstrate to me who that person is. You haven't done that. So therefore,
Why $15,000 when I've already been tried and hung on the first set?
you're not people can commit violations, repetitive violations. And there have been a number of them so far. So that I don't
In
see.
the beginning, when I went for the bed and breakfast thing, I had no idea, and that was all dismissed, and we, took care of that through the courts, and now I'm being tried for that again.
You're being tried for that particular advertisement that constitutes holding your property out for
I agree.
short-term rental.
I agree with that, but that's
And so-
not the second offense. I mean,
Thank
that
you,
would be
thank
the
you.
first time it showed up since 2020.
Okay, ma'am, I'm going to, in case number 3, I hereby find the respondent Georgia, case number 3. Case number 5, I hereby find the respondent Joanne DeBaron King in case number RTL 052530 as the owner of the property at 507-509 Jessamine Boulevard, Daytona Beach, to have been in noncompliance of Article 4, Section 4.1A and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs, and cannot be undone as provided for by Section 162.9(1)D Florida statutes, and the property has subsequently been brought into compliance on May 6, 2025, and hereby order that the respondent shall pay a fine in the amount of $15,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Okay, no, they leaned on the house for that, because I certainly can't pay that.
Ma'am, it can become a lien against the
Kevin
property.
can explain that process.
Or
Sorry?
He can explain the process to you.
Or if you find someone who knows how to contact VRBO and provide evidence of who placed that ad to show that it wasn't you, then that can come back as, I guess it would come back as a lien review. There are many ways to go there, but based on the evidence that I have currently, I have no choice.
Okay, Mr. Riggio.
Yes.
Case number 1 is here now, if you want to hear it, or however you want to proceed with that.
Case number 1, lien review?
Nope, case number 1 that we already went over.
Oh, an issue.
They weren't present, but they
Okay.
are here now.
We've already ruled on this case. The city objects, but we'll defer
That's
to you.
why
I'm willing to allow them to come forward. Good morning. Ma'am, sir, you will need to be sworn in as witnesses or sworn in as respondents.
Yes, please state your name.
Marie Kato?
Okay. And if he's going to speak as well,
Yeah, that's my husband.
state your name.
Mario Catul.
Okay. And if you'll both raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay, just so that you're aware, this matter was you were notified that there would be a hearing that started at 9 o'clock in the morning. There was no one here, so the case was heard by me. And as a result of Mr. Yates' statement that you had rapidly taken down the advertisement, I had assessed a fine of $1,000, which is the normal fine that is assessed in these situations. You are now present, and I assume you have a good reason for not being here at 9 o'clock when these...
I was in the building, but I went down, the GPS took me downstairs. When I contact somebody in the office downstairs, they sent me all the way near the bridge. Then when I went to the bridge, they told me this is where I have to come back.
Okay.
That's what happened. But I was in the building at 9 o'clock.
Okay, well, what I'm going to do is give you an opportunity to, why don't we just take this from the top, and Mr. Yates will explain the violation, and Ms. Diaz has some statements she will probably want to make, and then we can hear from you.
Thank you.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed July 10th, 2025, and they were notified the same day. The property stopped actively advertising as of July 18th, 2025. The daily posted rate was $212. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to these actions, the city is requesting a one-time fine of $1,000.
Okay. Just so it's clear, did I read in the case title on this one? That it's case number 1, RTL 082542, 5 Family Houses LLC, who's been cited for failure to correct violations of Land Development Code Article 4, Section 4.1A, Article 5, Section 5.2.82 at 815 Vernon Street. I'm just reading that in so that if somebody is watching this or whatever, they know what we're talking about. Okay. Ms. Diaz?
Earlier, I read a speech that was general to all hearings. You weren't present, so I'm going to repeat it. It's the city's position. The city's position is that the beneficial gain to the property owner whose advertising conduct that is prohibited by the city's code is unlawful and pursuant to Florida Statute 162.06, subsection 4, is irreparable and irreversible. The information advertised has long-ranging effects in luring in patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertisement can potentially book a property for the whole year, and we have seen gains of thousands of dollars. These promised days are potentially to the detriment of the patrons and definitely to the detriment of the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspection, proper licensing, proper insurance, and proper taxation required by law. Properties who have staff on site 24/7 to address any emergency concerns patrons or the community may have. This right here is the reason that we're here today. The community, I forgot which event, I think it was a truck event, destroyed neighborhoods. People came in playing music at all hours, having increased crime, and this is in a residential neighborhoods with neighbors right across the street. And these short-term rental owners weren't there at 3 a.m. to curb the behavior of their guests. Residents had no other means to fix the problem than to call the police in their neighborhood. It caused unrest and a demand to our city that we end this behavior. Weighing these short-term rentals against these unregulated short-term rentals who weighing the short-term rentals against people who have to go through regulatory safeguards is unfair and harmful to the regulated businesses and patrons in the community. The monetary effects of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against lawful accommodations, businesses, and vacation rentals. The transient nature of the rentals limits the mean of enforcement, typically to identifying the advertisement, because by the time code enforcement arrives to the property, the transient patrons are typically gone from the property or claiming a misleading relationship that are often contradicted by advertised visitor comments. The community effect is that the transient business used within unauthorized residential neighborhoods affects density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods. It diverts from traditional, reliable residential norms. State law adopted by the city defines vacation rentals to include advertising for transient guests. We do not need to prove guest reviews, payment, just advertisement. Therefore, the city requests a finding that these violations are irreparable and irreversible in nature. Also, given the gravity of the violation, a fine of up to $15,000 is warranted pursuant to Florida Statute 162.09, subsection 2D. Thank you.
Okay. Ms. Diaz, do you have anything further? Mr. Yates, anything further?
No, Your Honor.
Okay. All right. Ma'am, this is your opportunity if you have something you want to say in your defense.
What I have to say is, first, I didn't know I couldn't do short window in this house. And before I did, I applied for the tax. I thought they will let me what else I have to do to this, if I can do it or not. I didn't know that, so I pay tax. They didn't tell me nothing. So as soon as I find out I couldn't do that in the area, and I called the company and tell them I receive a letter. I'm not supposed to do that service in the area, and they have to put it down. That's what I did, and I called the electricity company, I called the water company, and then shut everything down. Because I didn't know. If I knew, I would never do that, because I have to follow the law. The law is the law. I would never do something if I knew not supposed to do.
Okay. Earlier, when I heard this matter, when you weren't here, basically what I heard was that the matter Mr. Yates had discovered the online posting, it contacted you, and you responded quickly.
Yeah.
Okay. And as Ms. Diaz has stated, there is an enhanced penalty, or at least the city feels that this warrants an enhanced penalty for these types of violations that allows them to levy a fine of up to $15,000. And what I had found in this matter at that time was that you had responded quickly, but there is still a fine that is imposed even for the people who act quickly and take everything down, and that's $1,000.
And they stopped on July 18th, so there was an 8-day delay, but
Mr. Yates
quick
felt
record.
that was warranted, providing that.
No, I did the same time I received it because I think the company didn't do it on, they didn't react the same day I called them. I did call them. And then when I called the tax company, explained them what happened, they tell me, you said you called to take the service down, and they still leave it in the air. Then that's when time I called them back and said, how come I call you guys to put the service down and you still let it in the air? That's what, I think that's why they took it. But I from the first beginning I did. Everything the first day, everything, I shut everything down. I didn't keep it.
Okay, but Mr. Yates's testimony was that the posting was made on July 10th.
Well, I think what she's saying is that she was dealing with Evolve, or one of the property management companies, and that
Yeah.
she called them that day to take it down, but that they lagged behind.
okay.
But not that it actually was down. I don't believe she's testifying
Okay.
that. She's testifying that she requested it come down that day, though.
Okay.
Correct, ma'am?
I,
Is that-
Yes,
I have a question just to get. So, did you say that you applied for a long-term rental license here in this building?
Yeah, I did.
You did? Okay, downstairs?
Yes.
And they gave you the license, and then after you got that license is when you posted the.
No, they didn't give it to me right away.
Okay.
I did fill application for the tax, everything I have to do, and then they didn't send me. They sent me, I received papers for the tax, but I didn't receive.
Did you receive papers like approving the long-term rental license, something that says that you can
No,
post
I
it?
didn't receive it yet.
So you posted it before you received the approval?
Yes.
Okay. Do you have anything further? Sir?
What I wanted to say, isn't it the obligation of Evolve to let us know if we were able to do this or not?
But you weren't approved yet, so you posted this listing before you were approved.
No. Evolve is his property management
Oh,
company.
okay.
And what you're going to find if you look in your paperwork, it's probably going to say that, and this isn't a for sure, but my knowledge of Evolve, it says that by signing this paperwork, you're saying you're allowed to do this. So in other words, most likely the paperwork you signed said that you can do this. So there, if not though, civilly, you could speak to a lawyer about their responsibility for this.
Who is Evolve? I'm so confused.
Evolve is a property management company. It's the largest Airbnb.
But they're not through the city.
No. They're a private entity.
So did the city give her a long-term permit license?
Well,
So everything you did was through a private company. So you didn't come here, no one here told you that you could do this. It was a private company that gave you this. Can you give me their contact information when you're done with, do you have it?
yeah. Oh, yeah. I have. They're the largest in the country. Yeah,
Okay.
I have them.
Well, okay.
And unfortunately, I'd say that by and large, we have the largest problem with them. They
Yeah.
certainly never call and check if
I
you're
will
allowed.
reach out to them.
Okay.
Nothing further.
Based on the testimony, or previously the city had recommended a fine in the amount of $1,000.
The city holds its recommendation.
Yeah, this sounds to me that the rental company sort of jumped the gun.
They don't
Yeah.
do any investigation, and like I said, they're the largest. You're one out of every 3 to 4 cases you see. They're the property manager.
Okay. Yeah, I mean, that the standard that I have applied in this has been the $1,000 penalty. And that is pretty much across the board with some various allowances in very unusual situations. So I had previously entered a finding. Ms. Diaz, does the city wish me to re-enter a new order based on the fact that we now have the respondent here and they've been allowed to present their...
Let me confer with staff.
Okay.
We will defer to your ruling. Our recommendation stays the same, just for consistency and fairness of all respondents.
Okay, so do you want me to make another ruling or just?
Yes, because they're here.
They are now here.
Due process reasons, yeah, we'll issue a new ruling saying
Okay.
after being heard.
Therefore, in case number 1, I hereby find the respondent, 5 Family Houses LLC, in case number RTL 08-2542, as the owner of the property at 815 Vernon Street to have been non-compliant of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner, damage surrounding neighborhood occurs, time the violation occurs, and cannot be undone as provided for by Section 162.091D Florida statutes, and the property is subsequently been brought into compliance on July 18th, 2025, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. All right. We now have 2 lien reviews, and they both seem to be related to one another. So let's take them independently. Lien Review 1, RTL 01-2201, property at 113 Azalea Drive. This is Sybil Redhead Estate. The new owner is Adiyami. Am I pronouncing that right?
Adiyami Abel.
Okay, Adiyami Abel. And at this time, there was compliance on July 1, 2025. And there is outstanding an amount of $16,900.95 in fine, recording fees, and interest. And we will need to swear in Mr. Abel.
Adiyami Abel, 12368 8th Street, Daytona Beach.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Mr. Stenson, could you give me an overview? Because it looks like there's a lot of complications in this one.
I'll see if I can make it easy for you.
Okay.
This particular case, we have previously met with this property owner, and we reviewed all the documents, all the legal documents there. There have been some errors in due process and the legal documentation. The city is recommending that we waive this particular lien.
Mr. Abel,
Yes, sir.
is that okay with you?
Yes, it is, sir.
Okay, I kind of thought so. So, with respect to this matter, let me this would be a lien reduction to 0.
Yes, sir.
Okay. Therefore, I hereby find that in case number RTL 01-2201 for property at 113 Azalea Drive, that the respondent, I'm sorry. Let me start over again. I hereby find in case number RTL 01-2201 for property at 113 Azalea Drive, I hereby order that the lien in that case be reduced to the amount of $0. I don't know that I need to say anything further. Okay, now the next case, Mr. Adiami Abel,
Yes, sir.
you're here for that too.
Yes, sir.
Case number CEB 0620-128, 113 Azalea Drive. Sybil Redhead, is that a state?
Yes, sir.
Okay. The new owner is Adiami Abel. There were a slew of violations. And at this time, as of July 1, 2025, there's an outstanding amount due on the property, $15,000 plus $24 recording fees and $4,152.96 of interest for a total of $19,176.96.
Yes, sir. This is almost the exact same thing as the last case. We have met with the owner, reviewed all the documents, all the legal documents, and we have actually re-inspected the property. All of the issues have been corrected, and we are recommending that we also waive this particular lien as well.
Okay. I see estate. Is this someone who passed on and left sort of a mess for the heirs or what have you?
Well, now is where it's going to get a little confusing. I'm trying to keep you out of that part, but
Is that usually that is the part that gets confusing? Is that there are, and will the end result of this be something better for the neighborhood?
absolutely, yes.
Okay, so rather than have a house that is being, and a property that is being squabbled over and looking like a junk pile, there's something nice that will hopefully arise on that property that will be good for all of the neighbors and the people who surround it.
The property has definitely been brought up to its former glory.
Okay, well, that is sort of the function of these lien reviews, is that sometimes there are things where the money is never going to be collected, and the only thing that happens is that the community is around it suffers because of a rundown property or.
No, Mr. Abel has been quite cooperative. He has multiple properties in the city. So
Right, that's why I'm saying he's stepped up. It's an estate property. I take it you probably purchased it from the estate or some.
Get in the weeds there.
Okay, but the bottom line is the city is a better place as a result of his efforts.
Yes, sir.
Okay. So, therefore, in case CEB 0620-128, property at 113 Azalea Drive, this was a Sybil Redhead estate. New owner is Adiami Abel. I hereby order that the lien in that case be reduced to the amount of $0. In other words, waived.
Thank you.
And it should do it.
Thank you.
Thank you.
All right.
That is all that I have, sir.
That was easy. Do we have any miscellaneous business?
No miscellaneous business.
Therefore, it being 10:31, I hereby call this session of the Special Magistrate proceeding for August 26, 2025 to be adjourned.